Commonwealth of Pennsylvania versus George Torsilieri, Mr. Gerald Morano, Mr. John Bartley DeLone, Mr. Aaron Marcus, Ms. Marnie Snyder.
Good morning. Appellee was convicted of indecent assault without consent and aggravated indecent assault, the latter of which subjects him to mandatory lifetime registration under the Sex Offender Registration and Notification Act, known as SORNA. The trial court found the registration requirements unconstitutional on several grounds. The Commonwealth has filed a direct appeal with this court challenging that decision. Mr. Morano.
Thank you. May it please the court. My name is Jerry Morano on behalf of the Chester County District Attorney's Office. Along with me is Bart DeLone from the Office of the Attorney General. I'll be relying mostly on my arguments that are focused in my brief, and I'll leave the remaining to Mr. DeLone. Essentially, this court is asked about subchapter H of SORNA, and I'll refer to it as subchapter H for convenience. We're not talking about the SVP. And you're asked to reverse the trial court, to defer to the legislature, and ultimately to uphold and find that this law is constitutional. When looking at the arguments raised below and the trial court's reasoning, there were basically 8 essential arguments put forth in the briefs. I'm not going to discuss all 8 of those. Rather, I'm going to focus my attention on 3 limited areas. Those areas will concern expert testimony, the statute is non-punishment, and in the alternative, even if it is punishment. And I think we have to start with one of the most important parts of this is the experts. Because every decision, every reason, every conclusion that the judge makes and defense advances is based on expert testimony, and more aptly, their expert testimony. Ultimately, this court, the issue today is who decides whether a sex offender poses a threat. And more aptly put, you will decide who decides. The Commonwealth's position is that the legislature decides, and that they've already made that decision. The defense's position is that it's the defense experts who will decide. The legislature's made specific legislative findings, and this court has always deferred to those. In fact, in Muniz, it recognized these legislative findings and how policy considerations are always to be given great weight and deference. But the trial court...
The deference doesn't make them irrebuttable.
That's correct,
The
sir.
legislature said no blondes can go to college, no blonde women can go to college because they're all dumb. We don't have to accept that.
That's correct. That's
So if the legislature here said anyone who is engaged in a sexual offense will recidivate, we don't have to accept that either. If somebody wants to build a record, which is what occurred here.
But in this case, the legislator made specific findings which are before the court. And that's one of the issues that the Commonwealth disagrees with, that there is uncontradicted evidence. The legislative findings do contradict the defense findings.
Counsel, may I just ask a question that's bothered me for years about this issue? And now you can answer it. I'm going to ask everybody this question. If the legislature is making a presumption across the board that one who commits a sexual offense will reoffend, why did the legislature enact a provision setting up the Sex Offender Review Board and included a required finding as to whether or not that alleged SVP will reoffend? If there is this irrebuttable presumption, why is that finding required before someone can be given the moniker of sexually violent predator?
I think to answer that in a couple ways. First, to start, the Commonwealth thinks that the legislature rewrote the laws to remove the irrebuttable presumption by allowing a mechanism which specifically allows a person to challenge whether or not they classify as pose a risk of reoffending.
When is that?
After 25 years, her lifetime.
25 years later.
Yes,
So
Your Honor.
Someone 25 years after the fact gets to establish that they will not reoffend. Although a sexually violent predator, when so designated, has to be based on a finding that they will reoffend. So we have someone who has never been found by the board, set up by the legislature, never been found to be a person who will reoffend. 25 years later, they could say, I'll never reoffend.
And I think the answer is that because they've held that the SVP is an additional punishment that can exceed that, whereas with the registration, the argument obviously is, to first point, it's not an additional punishment. There is no additional facts needed.
But my point is, if there is this permittable presumption by the legislature that all sexual offenders will reoffend, why is it required that someone who is designated as the worst of the worst has to be based on a finding by an expert that he or she will reoffend?
I think it's simple because that's an additional thing. The SVP will still meet the first qualification. They'll still have to register. That's an additional finding on top of that. So it's an extra finding, and that's why I think the legislature provided that. And I think that's the point. Had the legislature intended and wanted to have hearings put in, they could have done so. The problem here is we're dealing with public policy. And what we'll learn from experts is this. All experts agree that some people, sexual offenders, might reoffend. And all experts agree that some people, registration may be effective. What they disagree about and what's at issue here is whose experts make that decision. Is it the General Assembly, which is essentially the will of the people, to make the decision? And the General Assembly did that. They said it is our policy and it's our legislative finding, because this law is meant to protect and not to punish, that we're finding that this is such a serious offense. And additionally, here's something else. You won't ever have an expert saying that sexual offenders don't reoffend. You won't have an expert saying that sexual offenders don't pose a danger to society, because that's simply not the case.
We know that certain percentage of anybody who engages in criminality will reoffend. But that doesn't give the legislature the right to lock them up. We know that crime begins at about age 13 or 14, and we know that it concludes at about age 38, generally, with lots of sociological evidence. The legislature can't lock up everybody between ages 13 and 38 to eliminate crime.
No, but
because we're the arbiters of the Constitution, and it's not constitutional.
It is, in the sense that the conviction is triggering it, not the age.
But the conviction had nothing to do with future dangerousness. The jury was not making a fact finding on future dangerousness. So I don't know how that, whatever, it doesn't matter what the General Assembly says when it comes to the Constitution. So how does your argument comport with our requirement to perform a constitutional analysis respecting this future dangerousness issue?
I think
and how is that part of the criminal trial, which went on to look retrospectively at the criminal conduct?
Yeah, well, I think that's part of it. When a person is charged with a criminal offense, they are charged not only knowing that there's a potential statutory maximums of fines and other conditions, they're also aware that if convicted of these offenses, you may deem to register. The highest due process protection we have in this Commonwealth and in the federal government is a trial beyond a reasonable doubt.
That has nothing to do with what the jury was called to pass upon there.
It is, because the trial determined the conviction, and the conviction triggers the registration. That's what it comes down to.
You're really making the other side's argument. You're arguing that this is a part of the sentence. It's a criminal sanction. I suppose the legislature could make registration part of the sentence, and that would certainly change the whole analysis, but that's not what they've done.
No, and that's not my point either. But even if it is part of the sentence, that's absolutely right. It's perfectly lawful.
Then you wouldn't be arguing that it's not punitive.
Well, I have that as my deferment. And the reason I say it's not punitive, if there's no other questions with the experts, is because of the Mendoza case and what this court did in Muniz. In Muniz, this court...
Let's try to conclude the one argument. You're succinctly stated, you're saying respectfully, and I appreciate that we cannot and nobody can challenge legislative findings of purpose of legislation. Is that correct?
No, no. What I'm saying is it's generally left to the deference of the legislature in making those judicial and policy considerations. Of course, this court can do whatever it says it can do. So I'm not saying it cannot do that.
We follow the law. So the legislature says sexual offenders are likely to reoffend and therefore they need to register. Somebody comes into evidence, regardless of whether it's this case, and puts on live testimony of uncontestable, world-renowned experts who say recidivism is quite low in this genre of crime. Do you have any problem with that as a counterstatement to legislative intent?
I guess that's the point of having a legislature, is that's up to the will of the people. They could vote the legislature.
You do have a problem with that. You would say that there can, and I'm just trying to sort of pin down your argument so that I got it.
I'm sorry.
You would say that a defendant is precluded from attacking legislative findings. Is that fair?
No, not always. Like I said, you always have to put it in the examination of does it comport with constitutionality, which I think is what Your Honor is saying. So yes, I would agree with that.
Justice Todd was interested in the
You were just beginning to address Muniz when you turned to answering Justice Baer's question. Do you recall where you were at that point?
Yeah, so what I was
Go ahead with that.
Thank you. What I was talking about is the second point of why the Commonwealth thinks that subchapter H is now constitutional is because it's no longer, as this court found, to be punitive. And in particular, rather than going through all 7 factors, I'll focus on the essential one. One of the primary concerns of this court in Muniz appeared to be the number of in-person reporting. And in Muniz, this court specifically found that number to be 100. And they said because of that number was 100, and that's such a high number, that is one of the factors that weighs towards punitive. Well, the legislature specifically addressed and amended this court's concerns, and what they did is they drastically reduced that number from 100 down to the minimum possibility of 34. So now, under the new version, it's a minimum possibility of 34 rather than 100. Another thing that came up a lot is the internet and the posting and all the, the material and information that's on the internet. Well, if you look at the law, there's essentially 14 facts that are required to be posted for registration. Of those 14, we have 11 that are already available in this case, and probably so in most cases, but specifically so in this case. The only 3 additional facts that were not already available and what I mean by already available, I mean they're available based on the defendant's arrest and his conviction. They're available online on the internet. Are a description of the defendant's physical characteristics, but his picture was posted on the front page of the paper, the defendant's car and license plate number, and I believe if the defendant is compliant with the law. And again, if he wasn't compliant, then he would be arrested, and then that would be available to the public. A lot of the cases that talked about the internet, comparing it to shaming, talked about you have to go through a court files and dig things out. That's no longer the case. Absolutely not true. In fact, yesterday, I just Googled this defendant's name, George Torsilieri, and you come up with a list of cases and articles that provide all of that information. So the Commonwealth's position is those additional facts aren't to be that relevant in finding it punitive.
Counsel, during your search, were you able to determine whether that defendant was your next door neighbor?
I didn't see that. No, I did not.
But that's part of the concern of the public policy with the registration such that someone who would enter that site can determine if a person indicated as a sexually violent predator was a neighbor.
And I think the same is true as if you found out your neighbor's name, you could look and see if they've been convicted. I think a convicted sex offender is going to have those same brandishment, those same problems getting a job, those same problems getting houses, those same problems dating and pro-social activities, whether or not they have to register. And then my final argument, if there's no other questions on that, it deals in the alternative. Even if this court finds it's punishment, there's basically three areas that I'll address that really don't have applied. And I think Justice Baer said correctly. Had the legislature wanted to include this as punishment, they can. So if you find in default this is punishment, this law would still be constitutional. Because it's nonsense to argue that it violates Apprendi or Alene, because those require an additional fact that is found by the sentencing court. There simply is no additional fact here. The conviction triggers registration, nothing else. The trial court, the sentencing court does not have to make any additional findings, make any additional reasonings. He simply says, this person's convicted. Does this conviction meet within this chart? If so, they must register. The second, again, it's not an illegal sentence. The legislature determines the sentence. As you pointed out, the legislature can make this a lifetime sentence. So if it's a sentence, it's legal. And in particular, the legislature also decides if it should be an individualized sentence. You know, you think about it, in the most lethal punishment we have aside from the death penalty would be life imprisonment. If you're convicted of first degree as a non-capital or second degree murder, there is no individualized sentence. The legislature said you get life. That's the same situation here. The legislature can do that. And then the third part.
But counsel, the legislature hasn't done that. As a matter of fact, they went out of their way to say this is non-punitive.
And that's correct, Your Honor. And this court struck.
To ignore the legislative intent.
No.
In order to accept that argument?
No, I'm saying if this court does as it did in Muniz and still find that the legislative changes were not sufficient and it's still punitive. The big difference in Muniz and here, Muniz was ex post facto, retroactive. This case is prospective, going forward. So that's why in Muniz, the finding that it's punishment was crucial and critical. In this case, it's not. And the last one would be an Eighth Amendment, and the Eighth Amendment simply refers to grossly disproportionate, and that's not here, and there's no categorical ban.
May I ask you before you sit down, or else if Mr. DeLone's going to do this, feel free to yield to him. I'm interested in your take on Judge Sarcione's due process, irrebuttable presumption analysis, which I thought was pretty persuasive.
Well, I could talk a little bit about that, and I'll start with the general thing that basically.
The reason that I was sort of focused on legislative findings because the irrebuttable presumption that forms the basis of the due process argument, if I understand it correctly, is that all those convicted of a sex crime will reoffend.
And that's not accurate. Okay. First of all, he's saying all, and you're right. That's what he says. We're not dealing with all. We're dealing with adults. That's a huge distinction because a lot of Judge Sarcione's opinion in reasoning under the irrebuttable presumption relies on what case? In re JB, which concerns juveniles. This court and courts unanimously have held juveniles and adults are different. So that's part one. The second part is I did a lot of research, and as I mentioned in my brief, I can't find any case that says if you have an opportunity to challenge that that's an irrebuttable presumption.
What evidence, so since you have this argument that the criminal trial can be deemed to be an adjudication for those purposes, think of the criminal trial and tell us what evidence would be admissible on behalf of the defendant at that criminal trial to rebut anticipatorily, I guess, this presumption of recidivism or this presumption that this guy is going to reoffend?
I don't think there is, but I think the legislature specifically wrote that into the statute that he can now do that after 25 years.
So this mechanism now somehow makes it survive Muniz because now they've put in this tweak that after 25 years of punishment, there's this removal mechanism. How does that affect those first 25 years?
I mean, think of it in this way. What about a statutory maximum? The defendant doesn't have a right to challenge the statutory maximum, whether it applies to him. If he's convicted, that's when it applies. That's the same argument here.
Is it the same? I mean, because we don't have that same statutory maximum here, right?
No, but
we don't have that life sentence you were talking about earlier.
No, but that's a similar argument, and that's what the similar argument would address Justice Donahue is. The SVP is like the additional penalty of a death penalty.
No, it's not. And I'm just going to, try to make this clear. I'll ask someone else. I mean, the point about the SVP is that there is a specific finding, part and parcel of that designation, that individual is likely to re-offend. So we have, not as an SVP, it's likely to re-offend. I mean, and so we have a legislature who is making a presumption that everyone will re-offend, and yet setting up a procedure where others can be found not likely to re-offend. And therein, for me, lies the dilemma. In answer to Justice Weck's question, what evidence could this individual put into the trial in order to rebut the presumption? One answer might be, I went through an assessment by the SOAB, and they found that I was not likely to re-offend. So I mean, there's a tension between the legislative finding that everybody can re-offend and a procedure by which some individuals are found inherently are not likely to re-offend. Therein lies my dilemma with the situation that's presented to us.
And there are states, Supreme Courts, which have struck Megan's Law legislation for lack of an individualized assessment, which is what I think Justice Donahue is saying to you.
Yeah, and one of the most recent ones is Alaska. And if you look at the Doe v. Alaska, you'll find 4 huge distinctions. Primarily, that case centers on one big difference, the Alaska State Constitution. Alaska's state constitution was recently amended concerning privacy rights with respect to computers. Pennsylvania doesn't have that. In addition, one of the things that was...
Go ahead and explain to you how that distinction makes the Alaska precedent inapt to our case.
Because what they said is that Alaska has this specialized protection dealing with computers and the internet that doesn't apply in Pennsylvania. A second part that was really important was Alaska had no legislative findings. Alaska relied on other jurisdictions and other judicial opinions. And the court noted, we don't have a legislative findings. Pennsylvania does. Pennsylvania has those legislative findings. And another thing too, Alaska noted there's no mechanism to challenge it. Pennsylvania again has that mechanism to challenge it. So, and one of the other things they even specifically mentioned in their opinion was that in their legislation, the legislatures did not include that a person who is registered has a diminished expectation of privacy. Pennsylvania legislatures did put that in. And then
we're going to hear from the Attorney General now because we understand your position.
Thank you.
You've ably advocated for reversal.
Thank you.
Mr. Chief Justice, and may it please the court, my name is Bart DeLone. I'm with the Pennsylvania Attorney General's office, and we have intervened in this action. Justice Baer, I'd like to start with...
Mr. DeLone, pardon me, you do need to pull the microphone a little closer. There you go. Thank you.
Okay. And we'd ask you, please, as always, I mean, you're free to argue anything you want, but we try to avoid redundancy
Yes, sir.
if you're advocating for the same result.
I'll try my best. I do think I would like to clarify one or two things that my co-counsel was saying. And Justice Baer, if it's all right, I'd like to start with the question you asked about when this court defers to legislative findings. And I'd like to suggest that this court has repeatedly, you talked about precedent, this court in Naylor, Parker, Hale, Muniz at 1217, this court has repeatedly said that you do defer to legislative findings when there is a lack of consensus on expert opinion. And as we've described in our briefs, there is clearly that here. We cited to one of the academic papers concerning the dark figure of sexual recidivism. And since there is no consensus, we would respectfully suggest that you follow the precedent and defer to the legislature.
And I appreciate that your office and you personally were not involved in this case at a prior level. But what do we do with the fact that we have a record here of affidavits arguing lack of recidivism and nothing rebutting it? No objection to the affidavits coming into evidence without live testimony. Obviously, no cross-examination, no cross-experts, etc.
Well, I think
we're constrained to decide a case on the record we have.
There's two things there, Your Honor.
Okay.
That might go to Mr. Torsilieri's individual conviction, or whatever the trial court may or may not have done correctly or incorrectly. But the issue here for us, and what our friends are doing here, is they're saying, because we've just presented some of the social scientists in one particular context in a criminal trial in a county, that disputes all of the legislative findings made by the General Assembly.
But if you're, this argument that you make and your co-counsel make would seem inconsistent with all of our jurisprudence, including Muniz. Because I mean, if you're correct, if you and your co-counsel are correct, I don't see how the court would ever have any role in taking that first prong of the test with respect to weighing the constitutionality of the irrebuttable presumption. I don't know. Going back to Justice Baer's initial question to your co-counsel, if the General Assembly says the sky is purple, right. Are we required simply to rubber stamp in a constitutional challenge a legislative finding? I don't understand where that comes from.
I wouldn't say rubber stamp, certainly not. In other instances where the consensus is otherwise, and I would refer to In Re JB, you definitely have the opportunity to say, wait a minute, that's not, the experts are agreed on this, and the General Assembly got that wrong. But as we've detailed here, this court has repeatedly said, including in Muniz, that when there is no consensus, we defer to the judgment of the legislature, because that's what the legislature does. With all due respect, this court doesn't have committees, and it doesn't make the kind of social science findings, and that's the focus and the function of all of the precedent I just cited. With respect to irrebuttable...
Would it be proper, given that this is not a test only as to this defendant, this is not even a test of criminal versus civil, this is a finding of facial unconstitutionality of a statute, would it be proper for us to remand for the development of a full record? I don't know that we can do that.
I think you could do that, but let me suggest why it would not be useful, which is because, as we've detailed in our briefing and as I just cited, there is no consensus in the social science, and remanding it back to, with all due respect, the trial court isn't going to change that fact. Now, with respect to irrebuttable presumption, which you raised, Justice Wecht, and as we detail in our brief, I think the key case there is Connecticut v. Doe, because this is not an individualized assessment of specific dangerousness to a particular person. This is a class of convicted criminals that the General Assembly has determined as a cohort are subject to being more dangerous. And you say that there's nothing like that in our jurisprudence. Yes, Your Honor, there is. This court and many other courts have said if you're convicted of certain offenses, then you may not own or possess or buy a firearm. And so that we would suggest.
You're analogizing collateral consequences of a conviction to a future dangerousness prognostication that was not found at the criminal trial.
That's right, because what happens, and the same thing in the firearm context, and I would refer this court to the decision we cited in our briefs in Layman, which is the legislature there, just like the legislature here, said, okay, we have a list of offenses. Now, these people have been convicted. They've gone to trial. They've had the full panoply of due process rights. But once they're convicted, we are going to assume a certain dangerousness for the class as a whole, not individualized. And we're going to say, because of that, you can't own a gun. And because of that, your reputation...
I think that's a good argument, but I'm wondering if it's somewhat question-begging. I mean, in other words, aren't you eliding the point? Aren't you just begging the question of punitiveness? I mean, we can agree, can't we, that firearm licensing, other collateral consequences, they have a regulatory aspect. And here, we haven't answered the question that we're here to address on whether this scheme is punitive, right?
Well, Your Honor,
we still have a role on that, don't we?
Oh, absolutely. You have a role in that, but let's keep in mind that with respect to subchapter H, you don't have an ex post facto problem. So that is one part of it that makes the punitive nature somewhat less significant. But again, even if you assume punitiveness, the question here is whether or not there's an individualized assessment. Here, there's not, and so you don't get to these due process issues, and that's what Connecticut v. Doe says. And we think the firearm analogy, frankly, is fairly apt.
Counsel, may I follow
Absolutely.
up with you with my question about the SOAB?
Yes.
There was an individualized assessment in this case, and one could challenge the depth of it or something of that nature, but there was an individualized assessment in this case that this individual was not a sexually violent predator, which includes the consideration as to whether or not he was likely to re-offend. And so I'm once again going to ask you to help me with my dilemma. We have a legislature who has made a finding that all individuals who commit sexually violent offenses will recommit, and at the same time has included a protocol to be followed to determine if someone is an SVP, which includes determining whether or not that individual will reoffend when they've already made the presumption that all of these individuals will reoffend. That's the inconsistency between the legislative finding and the entirety of this legislation that causes me to pause on the basic notion that they're even making an assumption that everyone reoffends.
Well, I wouldn't, with all due respect, Your Honor.
I'm asking you for your
Yep,
insight.
absolutely. Let me try and help. But I think the presumption is there's a greater risk of recidivism. I don't think the presumption is everybody will reoffend. And I think the difference between SVPs and the sexual offender, the SOAB process, is that they're looking for something different. They're looking for something specific about the mental capabilities and abnormalities of the people involved, and that the finding that the General Assembly reached with respect to sexual offenders was sort of not that narrow and not frankly focused on mental illness, just focused on, even if you're not an SVP, which is what the SOAB determines, you're still being convicted of a sexual offense, and the risk of recidivism, as the General Assembly has found, is still there.
Even though, take this individual, for example.
Yeah.
He went through the assessment.
Right.
Finding not an SVP. Included within that finding is a determination that he is not likely to reoffend. How do we comport those two contradictory elements of this case created by the statute?
I think, Your Honor, that the SOAB system is to try and distinguish between those who have mental difficulties and those who do not. And I think as part of that, there may be a view that because they're not an SVP, they are less likely to reoffend, but that doesn't change the generalized finding with respect to anybody who's convicted of these series of offenses.
But along those lines, counsel, and I appreciate your insights on this, really. If the SOAB makes a determination that someone is suffering from a mental abnormality, but is not likely to reoffend, that person is not going to be designated an SVP.
I'm sorry, can you do that again, Your Honor?
One of the findings that's required in order to get the moniker of SVP hung on you is that you are likely to reoffend.
Right.
So someone can have a mental abnormality, but is not likely to reoffend. That person will not be an SVP.
That's correct, Your Honor. But again, the findings of fact of the General Assembly here are more generalized. They are saying...
I understand that, and that's, I believe, what the challenge is, the inclusiveness of it. I believe that's, in fact, what the challenge is based on.
And I understand that too, Your Honor, but I think that's one of the reasons why these due process issues that have been brought up by my friends are not applicable here. And again, I would go back to Connecticut v. Doe. Just very briefly, the trial court went beyond procedural due process and into substantive due process. We don't think that was necessary, and we think actually it was inconsistent with this court's decision in Clayton, where there you did have an individualized assessment, but they looked to the procedural due process. They didn't look to, they said basically, you said basically, look, we don't think you should pigeonhole this one way or another, but then when they did the analysis, they looked at Bell v. Burson, which is a procedural due process, and we think that's the proper way to do that. But even if substantive due process was correct, as we point out in our briefs, again using the analogy to firearms, Justice Wecht, there are many courts out there that have first under intermediate scrutiny said this clearly meets the reasonableness test under intermediate scrutiny. You have public safety and you have this, I'll call it a proclivity for possible greater recidivism. That's an easy one, and I would refer you to the case we cited, Marziala, which is a Third Circuit case. And then courts have also decided, well, even if we're not going to do intermediate scrutiny, we do strict scrutiny. I would refer the court to the Merritt, McCoy, and the Eldhart cases that we cite, which basically say, look, the way you do the narrow tailoring here per Grutter is you look and you say, who is the class that we're talking about here? It's these class of specific convicted sexual offenders. That's enough narrow tailoring, as these courts say, to satisfy strict scrutiny. So we don't think you need to go down the substantive due process road. If you do go down the substantive due process road, we think it's intermediate scrutiny. But even if you do both of those things, it satisfies the test under strict scrutiny.
Mr. DeLone, before I think you're about done, I know we've already covered this, but just one more time, because I'm trying to grasp it and having trouble. Perhaps it's my malady. What Judge Sircone held was that the legislature has set up an irrebuttable presumption that sexual offenders remain dangerous. That presumption is not universally true, and there's a reasonable alternative to that broad presumption through individualized assessment. Now, tell me succinctly and precisely where he went wrong.
Okay, the first thing he did wrong was to suggest that there was an individualized assessment. There's not. And as I said, if there's no individualized assessment, there's no due process is not implicated per Connecticut v. Doe. With respect to the universality, that goes back to our discussion on what the General Assembly found.
Right.
And the case law I cited that says we have dueling experts on this. And given what this court's precedent has said, you have to defer to the General Assembly if there are dueling experts, which there are here. So you take that as true. With respect to the reasonable alternative means, Your Honor, there are all sorts of different ways the General. You had this discussion with my colleague in the previous case. There's all sorts of ways the General Assembly could have set this up. But the question before this court is, in the way they set it up, without an individualized assessment, is there a reasonable alternative means? And going back to our discussion again, Justice Baer, given the roles of the legislature and the roles of this court, and given the fact that this is not an individualized assessment, that this is a finding in the legislature of public policy,
Well, then
we don't think
sorry, just jump in on that, just to follow up on Justice Baer's question. So then, under your understanding, the legislature could take a look at anything in the Crimes Code, or anything, I guess, in pardons, and just say that categorically, any class is a group that we judge in our unquestioned legislative prerogative to be potentially dangerous. And so whatever consequences ride along with that are ipso facto constitutional.
Well, no,
Right?
that's no, Your Honor. That says too much, because if you look at In Re JB and you look at what this court said in Muniz, and you look at what the General Assembly said in 9799.11, there has to be some basis for this. There have to be social scientists or witnesses somewhere that say there's a basis for why we consider these people as a cohort.
So we're supposed to look at the statute and see if they've cited social sciences?
You're supposed to see whether they're finding, just like you did in Re JB, Your Honor. You're supposed to look at their findings and see if there's a consensus. If there is a consensus, then you certainly leave it alone. If there's a consensus on the other side, you say, well, wait a minute, this doesn't make any sense.
But scientific consensuses change.
They do, Your Honor, they do. And as a matter of fact, with respect to juveniles, I think there was a change.
Counsel, if I may, are you finished? Quick question. You keep referring to Commonwealth versus Doe. My only concern...
Connecticut v. Doe, Your Honor.
I apologize. Connecticut v. Doe. My only concern with that case is, and correct me if I'm wrong, is this: we can distinguish that case. That case was based upon the fact that Connecticut did not have a liberty interest or a fundamental right to reputation, and it was based upon reputation, wherein we in this Commonwealth specifically do.
No, Your Honor, because in Connecticut v. Doe, the United States Supreme Court assumed a reputational liberty interest in their analysis. So it's just like here.
Okay.
Thank you.
Thank you.
The chief's back.
Marcus, who's arguing on behalf of the appellee? You are?
Yes, Your Honor. I was going to request that we be able to split our time between myself arguing the due process or addressing the due process considerations and my colleague Marnie Snyder, who would address any of the punitiveness questions that this court may have.
Typically, if we have one defendant, we have one lawyer, because we have a lot of cases, you see, and there's a lot of people that would like to bring 3 lawyers.
Well, I'm happy to address any of the questions on any of the issues this court may have, Your Honor.
4 lawyers.
Yes.
See if you can handle the presentation on behalf of the appellee, please.
Will do, Your Honor. Thank you. Your Honor, Aaron Marcus, on behalf of Appellee, Mr. Torsilieri. There are a number of issues I'd like to respond to, and instead of going through each one, let me start with Justice Donahue's question, as she already said she was going to ask every single person who...
I was hoping you wouldn't make me.
So I will start with that, and we would agree with you, Your Honor, that there's definitely a tension here between the SVP assessment and then the declaration that the legislature has put forward regarding what everybody, or the message being sent that every single person who is required to register under SORNA is a, quote, high risk, i.e. a danger to the community, right? And that's the message that is being sent. What's fundamentally...
Not precisely the message, though, is it? The message is that in this class of criminal offenders, sexual offenders, the legislature finds that there is a high likelihood of recidivism. It doesn't address individuals within the class.
So this is the Commonwealth's argument that raises this idea between the group versus individual idea. And I think that's sort of a flawed argument for a couple reasons, Your Honor. First off, is that any time a class is being identified by the legislature, and there is a presumption at issue, and we're dealing with that as far as defining the class, there will always be some sort of overarching principle that the legislature is saying, we're going to say as a group, all of these people are included in the class. However, right, when we're dealing with the right to reputation, that's not the message that is being sent to the public, and it is very clear that that is not the message that is being sent to the public. The issue here is about individualized determinations of harm as far as the individual reputation, right, or the likelihood of harm.
Well, but isn't the message they're intending to be sent is that because we find the literature, the scientific and social expertise in this area led the legislature to believe we may have counter expertise on it, but led the legislature to believe that this class of people, this class of convicted sex offenders, is more likely to reoffend, and therefore, in the interest of public safety, the legislature believes their action was legitimate. Isn't that the message they're trying to send, one of protecting the public?
The goal is trying to protect the public.
Correct.
The legislature is attempting to do that, right? The evidence, I think, is overwhelming that that is not a successful outcome based on the class that they've defined. That will not be achieved. But the message being sent to the public and how the public perceives that, in the legislative findings, they say all sexual offenders pose a high risk of reoffending, right? And sexual offender, that term, as a term of art, includes, and I was going to respond to Justice Donahue, both SVPs and everybody else, right? The message is being sent as this class to individuals, and let me step back for a minute. When somebody goes to the website and sees a page with a photo on it and sees the information saying this person is on the registry, right? The message being sent is not, well, as a class, this person may have an above average risk, but they may not. That's not, right? It's not about, over a class of the 22,000 people, right? There is an average rate, according to the legislature, that might be higher than the standard rate of everybody else who might have been convicted of a crime at the time they were put on the registry. Although the evidence seems to suggest that after periods of time, and including some people right away, are actually below the relative rate of anyone else who is convicted of an offense, right? I mean, the grandmother who's convicted of interference with custody of children, right? Now, the legislature in subchapter H minimized that, but there are numerous offenses that have no sexual component, right? But the legislature is including them. If I see that on
They corrected that.
They only corrected a portion of the interference of custody of children. They did not eliminate that from consideration in the statute as being included within SORNA. They altered it to eliminate if the person is a parent or, I think, a close family member, but that doesn't include aunts, doesn't include grandparents, it doesn't include family friends. And that doesn't deal with sort of kidnapping, unlawful restraint, false imprisonment. But the message being sent is to the individual so that person who sees that photo can take action, supposedly, regarding the person living next door and have a particular message about them. They're not thinking about average rates. They're thinking about this person's a high risk of reoffense. And let me also
action, as I understand what the legislature is intending to do, the action to be taken is the information is to be available so that you can protect your children, so you can protect your neighborhood.
Well, so that's the goal that the legislature is trying to obtain, right? Because the ultimate end is public safety. That's what the legislature is trying to do here. So if we want to think about that as far as a means to an end question, that's our substantive due process challenge here. Right? It questions the means that the legislature has chosen, the policy choice that the legislature has made, what those means are, identifying a class, the length of time, how we identify that class, and what we're requiring of them, registration, notification, etc. Does that achieve the end of public safety? Right? Now, I think this helps get into the question of deference in some real ways, because when we think about levels of scrutiny and what we put legislative policy choices and findings to by this court, we are thinking about essentially a proxy for the interests at stake and how much scrutiny this court will put legislative declarations and legislative findings because, for instance, in rational basis, we allow the legislature to experiment, essentially, with public policy to achieve potential ends if they have a rational reason for doing so. We think, as if I'm representing the legislature, it might, have an effect on public safety. And this is a compelling interest, preventing sexual offending. We want to go ahead and engage in something. So in that respect, right, the legislature on a rational basis test gets to experiment and try out policy choices, regardless of whether they might ultimately be a success or failure. However, when the interests are fundamental, and I think there is no question left for this court to decide regarding whether the right to reputation under Pennsylvania's Constitution is a fundamental right. I mean, in 3 cases recently during the 40th investigating grand jury, this court walked through, in some respect, the history of that, indicating how fundamental that right is in Pennsylvania. As, I think the quote is of, the highest plane along with life and liberty, no lesser order precept. When we apply strict scrutiny to that, right, there is much less deference given to the legislature because essentially we're saying while they're allowed to make a policy choice, that choice has to be put to the test by this court and courts to determine whether it's constitutionally appropriate. And when the fundamental rights are at stake and are being deprived here, the court has to say, legislature, you need to get it right the first time. You can't experiment, right? And that's really part of, I think, what the issue is as far as the deference here. The legislature is not deserving of absolute deference, indefinitely to their determinations of policy, certainly, and even their findings of fact. I mean, this court overwhelmingly has rejected factual assertions, which are basically as minimal as they are here. The Commonwealth, by the way, in a substantive due process analysis, has the burden to establish that the law is sufficiently narrowly tailored to meet its compelling interests. The government in this case, the Commonwealth nor the AG, they have done nothing other than to say, in this matter, look to what the legislature's one sentence of finding. They didn't introduce... Counsel,
but they didn't have, in fairness, a real opportunity to do so. At the time this case was bouncing around the lower court, nobody appreciated that it was going to become an 80-page, very fine trial court opinion finding the statute facially unconstitutional. What we have in this record to counter what Mr. DeLone says are fair legislative findings, which can be supported by evidence, is 2 affidavits. We don't even have testimony subject to cross. Well, there is, as you know, a strong presumption in our Commonwealth that legislation is constitutional.
Yes. So let me respond to that in a couple ways, Your Honor. First, I think there should have been no question from the Commonwealth how significant this was to begin with. The party submitted, an
I actually
80-page
believe that
memorandum.
The Attorney General didn't know of the existence of this case
Well,
until they got
and
notification of the
and the
decision.
attorney general didn't ask for a continuance. The attorney general said, "I agree that my friend here would be sufficient to adjudicate this," and he didn't suggest. They stipulated to the affidavits. This is like JB, where there was evidence presented. The conversation was.
I'm just trying to make sure the facts are right. The AG stipulated or the local DA stipulated?
The local DA stipulated, and the AG did not object to that stipulation. The AG objected to the consideration of the evidence on the question of its value to the court. But
Is it accurate that the AG was not involved in this case until it got to this court?
that's accurate. It's not accurate. It was involved in the court at the trial level. They appeared at the argument hearing for this matter. The AG appeared. They were aware of it. They came in and basically deferred to the Commonwealth.
You're claiming that the statute's constitutionally infirmed.
Yes, Your Honor.
Based on the relevant constitutional test to be applied.
Yes, there are.
Believe me, we understand the argument that this presumption built into the statute is constitutionally infirm.
Yes, Your Honor. That is quintessentially the argument under the due process standards. Unless this court wants to hear on punitiveness.
In fairness, Ms. Snyder, do you have something you'd like to add because you've come here and...
I would be available to address any questions that the court has on punitiveness, though I know that we went through some and hopefully address some
Step up to the mic.
with Justice Donahue in that matter. I do believe, as Justice Wecht said, that social science changes, and I think this is exactly what it changed to. That the evidence from 3 world-renowned experts that was stipulated to has kind of changed the game. And that's a lens through which we need to look at substantive due process that Mr. Marcus covered and the factors, the Mendoza and Martinez factors for punitiveness. Not that they changed those factors or what this court should be considering, but how serious that is and how serious the restraint is also built in. One of the more important things I wanted to speak to the court about was restraint, if anyone has any questions about that. And if not, I understand, Justice Siller, your position, and I would like to remain brief.
Well, it's an important case. We don't want to cut anyone short, but typically we only have one. Anyhow.
Understand that.
Anything else? Any questions?
No.
Thank you.
Thank you.